basically the most out-of-touch branch with the average person is the judiciary.
Yes.
At some point, they started, or let's put it this way, we as the average citizen started listening to the judiciary as the highest power. And you know, in my mind, honestly, the Supreme Court says something, that's it. You know, that is law, and there is no higher voice in the land. But what you're saying is really the Founding Fathers were wanting to separate those powers. They were wanting to put the judiciary in its place. And we have believed over the many years 5 myths in regard to their power, and we just buy it.
Let me pick up something you said. You have come to believe that when the court says something, that's just the way it is. That's law.
Right.
Do you know what the title is on every single Supreme Court decision, and has been since back in 1789?
No, sir.
The first line says, the opinion of the court. It doesn't say the law of the court. It's the court's opinion. Now, since when did we allow the opinion of the majority of 9 individuals to become the equal of law? And this is one of the most intriguing things. If you take a tour into the U.S. Supreme Court right now, as you go on the tour, they will stand in there. The tour guide will tell you, this is the building from which all the law in the land emanates. You go, wait a minute, time out. What's that big dome building across the street where they make laws?
Wow.
And they said, no, all law comes out of this. On the court decision, it says the opinion of the court. The significance of that is the Founding Fathers told us in the Federalist Papers that all 3 branches are capable of determining constitutionality.
Oh, my goodness.
The President reads it, he takes an oath to uphold it. Congress reads it, they take an oath to uphold it. Courts read it, they take an oath to uphold it. Well, what if their opinion of constitutionality is different from the President's or from the Congress's? Does that mean that these 2 have to bow down to what they say?
Oh, my goodness.
That's why it's only their opinion. Now, what would happen? Congress would pass a law. The court would say, our opinion, this is unconstitutional. Congress would say, we hadn't thought about it from that standpoint. That's a good point. We'll go back and change the law. Well, it's their opinion. But on the other side, you had people like Andrew Jackson and Abraham Lincoln, and you had Thomas Jefferson, and you had James Madison, who said, that's your opinion, and it's dead wrong. Under the Constitution, for example, Abraham Lincoln, under the Constitution, there's nothing that says blacks are property. That's your opinion. I'm not following it. I'm declaring slavery to be ended in Washington, D.C., and I'm even going to issue the Emancipation Proclamation, both of which were direct pokes in the eye at the U.S. Supreme Court, who told him he couldn't do that. But he's just as capable of determining constitutionality as they are. That's why it's the opinion of the court. One notable case occurred in 1841 and dealt with the Spanish slave trading ship La Amistad. The case proceeded through the legal system, and an elderly John Quincy Adams was called in to argue this case before this Supreme Court. In what became his last words ever spoken before the Supreme Court, Adams stood in this very room, reminisced about the changes he had seen during his long life, and then closed by offering his heart's prayer for each justice then sitting on the bench. He told the court,
"May it please your honors, on the 7th of February, 1804, now more than 37 years past, my name was entered and yet stands recorded as one of the attorneys and counselors of this court. 5 years later, I appeared for the last time before this court, for shortly afterwards, I was called to the discharge of other duties, first in distant lands and in later years within our country, but in different departments of her government. Little did I imagine that I should ever again be required to claim the right of appearing in the capacity of an officer of this court. Yet, such has been the dictate of my destiny. I stand before the same court, but not before the same judges. As I cast my eyes along those seats of honor and of public trust now occupied by you, they seek in vain for one of those honored and honorable persons whose indulgence listened then to my voice. Marshall, Cushing, Chase, Washington, Johnson, Livingston, Todd. Where are they? Where are they all? Gone. Gone. All gone. I humbly hope and fondly trust that they have gone to receive the rewards of blessedness on high. In taking, then, my final leave of this honorable court, I can only offer a fervent prayer to heaven that every member of this court may go to his final account with the approving sentence, "Well done, good and faithful servant. Enter thou into the joy of the Lord."
If there is a federal court that says if you pray at a school, we will come and lock you up, they have power to send a federal marshal.
They don't. See, all they can do is render the decision. The executive branch executes the power. All federal marshals are under control of the president, not under control of the courts. So this is something Congress has started doing in recent years. The courts say, we order you to get that 10 Commandments out of the courthouse. Congress quickly comes in and says, not a single penny can be appropriated to move those 10 Commandments out of the courthouse. Well, if you can't appropriate money, then the marshals can't go in to do anything because they get paid by the federal government. They get paid through the executive branch. So what's happened is there's a lot of ways to... See, federal marshals don't work for federal judges. They work for the president. They're appointed by the president. They answer to the president. They're under the Justice Department, one of the executive branches under the president, so they can issue opinions all day long. This is why when Andrew Jackson was president, John Marshall issued an opinion on a certain subject. Andrew Jackson said, "That's your opinion. Let's see if you can enforce it." That was his response. Because the courts have no power to enforce opinions. The other two branches do that.
You know what you've just done for me? You've just changed my opinion about the judiciary, and this is how. They have no authority. So only what I believe about their opinion is what governs
Only
me.
what we allow them to have is...
Oh my
if we will
gosh.
simply go back to the documents, go back and read our history to see how those who wrote the documents applied it, it's a no-brainer. America is fine, but it starts up here. Until we change what we know, we don't change what we allow them to do.
For more information on the American Heritage Series or to find books and other resources, visit wallbuilders.com. Through the American Heritage Series, renowned historian David Barton communicates our nation's forgotten, godly foundations and encourages us to once again view history through a truthful lens. For only when we recognize and embrace God's hand in our history can America become all that it was intended to be. Through Wall Builders, historian David Barton seeks to rebuild the walls of America's unique religious, moral, and constitutional heritage by educating the public and encouraging people of faith to become active in strengthening America's great foundations. For more information on how you can become involved, visit wallbuilders.com.